Starting a court case. The civil justice structure was revamped after the Woolf Commission in 1999. The parties are allowed to give evidence to each other in an effort to eliminate the need to launch too many court proceedings. Therefore, when a claim comes to the court, in particular in situations of serious injuries, a protocol pre-action will be practiced. That is a list of items to be performed because the respondents may not obey the protocol to send the relevant material to the other side, they will be responsible for any damages because they present a complaint to the judge. The material is generally given in a letter detailing briefly how the claim arises, whether it is alleged that the other party is at fault, specifics of the accident or other damage, and any other related matter. The claimant shall then be granted 3 months to review the allegation and shall then respond, pointing out if the responsibility is admitted or whether it is rejected, including the justification for the denial. If expert testimony is required, the parties will seek to consent to the usage of one expert. That will contribute to a lot of cases being dismissed, but there would also be those who continue to proceed to arbitration. Issuing a claim. When you choose the county court, you can opt to bring a lawsuit in either of the 230 or so county courts in the country. If you are using the High Court, you can switch to either of the 20 district registers or the Central Court of Town. You need the N1 argument form. The court office may supply you with instructions detailing how to fill out the request. Court workers will help you ensure that you have finished the application form correctly, or you can seek support from rehabilitation centers or the Citizens Advice Bureau. When you have finished the application, you can photocopy it so that you have a copy for the trial, a copy for yourself and a copy for each defendant. And carry the document to the courthouse. The charge for filing the claim will be charged by the court. The fee depends based on how long the statement is about. At the beginning of 2013, the charge for a claim of up to 3:00 p.m. was $35 p.m., and the highest cost for a limited claim, under $5,000 p.m., was $120 p.m. Representations of £5,000 to £15,000 had a fee of £245, whereas representations of over £300,000 had a fee of £1,670 at the peak of the scale. Defending a claim. There are many paths that can be followed as the claimant gets the claim document. They can accept the claim and pay the full sum of the claim. The situation stops when this occurs. The complainant has accomplished what he desired. In other situations, the defendant can challenge the allegation. Unless the claimant wants to answer the lawsuit, he or she will give either an acknowledgement of service, Form N9, or a response to the court within 14 days of receipt of the petition. Unless only an acknowledgement of operation is received, the offender will have a further 14 days to represent the defense. If the defendant refuses to do any of these items, the applicant may ask the court to require the defendant to pay the money and costs alleged. It is considered an order by nature. If the case has been decided, the court must assign the case to the most suitable line or form of coping with the matter.